Well, good afternoon. My name is Charles Vidic. I'm the Senior Project Manager at Western Connecticut Council of Governments. I'm joined by my colleague, Tucker Bennett, Planner at WestCog. Today, we will review the special development zones and their role in addressing a range of land management needs faced by municipalities in Connecticut. This training course reviews the types of special development zones used, their common applications, the legislative and case law authority for their use, and their strengths and weaknesses. The goal of this presentation is to familiarize you with innovative zoning approaches to addressing a wide range of economic development, housing, village design, and environmental responsibilities you have as a Planning and Zoning Commission member or member of a Zoning Board of Appeals. This 1-hour training fulfills your requirements to receive at least one of the 4 hours of training relevant to your role as a Planning and Zoning Commission or Zoning Boards of Appeal member every 4 years. If your term is longer than 4 years, then you must receive the required training during the term of your service on the commission. This training is the first to provide a statewide analysis of current special zoning district practices based on a very comprehensive study completed by WestCog. So it's a unique presentation that you'll hear nowhere else. So let's start with just the overview of our agenda today. As you can see from our agenda, this training session will address the purpose and applications of the 4 special development techniques: floating zones, overlay zones, planned development districts, and village districts. So we'll start with a review of basic definitions of these zoning techniques and their legislative history. You can go right on. Let's start with floating zones. They're a special development zone that do not apply to any given property until an application is made to land the zone in one or more locations for parcels that meet the eligibility requirements. The key eligibility criteria are called tethers, since they determine whether a floating zone or where they can land. For example, specific zones, specific highways, or specific parcels greater than a certain size are examples of commonly used tethers in Connecticut. You can go to the next slide. So let's talk about overlay zones and planned developments. Contrast to floating zones, overlay zones supplement and generally do not replace the regulations found in the underlying zone. Overlay zones are often used to address unique environmental or watershed protection concerns that do not align with basic zoning districts. They may exist within one base zone or cover multiple underlying zoning districts within a municipality. Planned development zones are created to meet unique housing or economic development needs that are not properly met by the underlying Euclidean zones, a concept we will discuss later on. Planned developments create new districts with their own height, bulk, setback, and development standards independent of the underlying zone which they replace. And then we'll go to the last of the 4 definitions here. And village districts is the 4th development zone we will discuss today. Like the other development zones, village districts created under the Section 82J of the Connecticut General Statutes are subject to landscaping, building design, and architectural review standards. They may be adopted as overlay zones or as a replacement for existing zoning districts or village district character or special architectural or landscape design are desirable features to be protected. So now we'll go into a little bit of the legislative history. So there's a lot that happened before we had this presentation today, going back to 1925, which is not shown on this slide. Zoning in Connecticut was enabled actually July 1st, 1925. So we're only, about 7 days away from the 100th anniversary of zoning in Connecticut, for those who were not aware of that. In 1959, when Euclidean zoning was modified to allow for special permits, it was modified to allow for special permits with any given zoning district. That was probably one of the most significant changes in the last 100 years after the 1925 enactment of zoning. So the Zoning Enabling Act of 1925 did not provide for any incompatible uses, but it soon became apparent that some uses might be compatible if they were managed under special permit standards. Soon other innovations emerged with the National Flood Insurance Program in 1968, creating floodplain zones. In 1969, the Connecticut Supreme Court upheld the use of floating zones in Stamford. And then in 1985, the legislature enabled the use of overlay zones to extend its use beyond that limited to the Coastal Zone Management Program. In 1998, the legislator added village districts as a new zoning tool to expand architectural protections from exclusive domain historic districts to be a tool for innovative village and urban design. 9 years later, incentive housing overlay zones were added to the list of special development techniques. And then in 2013, the Connecticut Supreme Court put guardrails on some special development practices in the McKenzie case to ensure the principles of uniformity, otherwise known as the Equal Protection Act, were complied with. And then in 2021, the legislature codified the Supreme Court's holdings that floating zones are a valid zoning tool. So we will go into more detail on a number of these important laws during this training session, but this gives you an overview of what's been going on for the last virtually 100 years. So we'll go to the next slide. This diagram provides a bird's eye view of how zoning has evolved over the last 100 years. When Zoning Enabling Act was adopted in Connecticut, there were only two types of land uses, those that were permitted and those were prohibited in any given district, because the world is not black and white and has shades of gray. As we mentioned earlier, in 1959, the legislature authorized the use of special permits to address uses that could be compatible with any given zone and meet the uniformity rule, provided they met more exacting standards of compatibility. As we discussed a few minutes ago, by 1969, the floating zone emerged as a flexible zoning tool that enabled a more negotiated approach to large-scale development. Since then, we have seen the use of master plans used to design specific districts using the flexibility of floating zone techniques. The point to be made here is that the uniformity rule, the principle that like uses are treated equally, has lost much of its historic meaning. Planned zoning districts like floating zones have landed and created new independent zones that are not judged for consistency with the zones they replace, merely for consistency within the zones they now created. This is a very important point, that there's a goodly number of zoning commissions that I've worked with that haven't fully understand that particular point. So let's go to the next slide, which shows the four special development districts with their relationship to special permits. Today, Connecticut zoning commissions have 5 key special development tools we just mentioned to address proposals that have inter-district or intra-district impacts not effectively addressed by traditional zoning. These 5 development zones are not equally well used across Connecticut. The most common tool is the special permit, which is nearly universal in use in zoning commissions in Connecticut. 166 of the 167 towns with zoning use special permits. There's only one exception. This slide shows the number of zones that exist in Connecticut for each type of special development district, not the number of municipalities that use them. So for example, there are 61 municipalities with the 102 floating zones. There are 51 municipalities with the 70 planned development districts, and there are 71 municipalities that are responsible for the 106 village districts that we have in Connecticut. And finally, the 139, there are 139 municipalities that have 421 overlay zones. By all comparisons here, overlay zones are one of the most popular zoning techniques, independent of the base Euclidean zones. While each of these five tools has distinct regulatory and legal applications, many of them bleed into each other based on the specific way in which the tool is applied. The important point to understand is that there are many examples where these tools are used jointly to achieve specific objectives. For example, there are 32 municipalities that have adopted a village district regulation in an overlay zone rather than as a separate base zone. Similarly, one municipality provides planned developments through an overlay zone. We will discuss some of the strengths and weaknesses of these tools in our discussions in each development approach shortly. Important to remember that with the exception of special permit-driven development strategies, all of the four zoning tools require changes to the zoning regulations and the zoning map. That's a key thing. So we'll go to the next slide. So all five overcome the uniformity rule, including the special permit provision. So now for the answer to the question on the previous slide, all five zoning do overcome that uniformity rule. And you can see that Section 8-2 of the general statutes requires each class of building structures use of the land throughout the district to be uniform. The only exception to that rule is a special permit process, because the special permit is like a quasi-district in its own right, even though it's not called that. For practical purposes, it has all of the same characteristics of a zone. But the difference is that a special permit can never have less restrictive standards than the zone, than the place in which it's placed. Whereas the other development standards, the four that we're talking about, have the capability to change those standards. So we'll go to the next slide. So as we can see, zoning has changed to address the rapid pace of development and need for large-scale approaches to development at the neighborhood and urban levels. This has been happening over the last 75 years. Environmental protection, transit supporting densities, and mixed-use development are some of the most prominent zoning concepts to emerge in the last 75 years. These ideas were poorly addressed in the Standard Enabling Act of 1925. Innovative zoning has occurred in three different levels of government. One through the state legislature, the second through the court system, and the third is through municipal zoning itself. And what we're doing in this presentation today is giving you a perspective on the legislative, the court system, and Connecticut practice, which I believe is the first time it's ever been given to understand all three levels of how zoning works in Connecticut. Euclidean zoning is often misunderstood to be based on the famous Greek name Euclid, who developed a system of geometry primarily addressing flat two-dimensional planes. In reality, Euclidean zoning refers to the US Supreme Court case that established the constitutional basis for zoning in Connecticut. The case, decided in 1926, is called the Village of Euclid versus Ambler Realty Company. So that put basically Ohio on the map and not the ancient Greek Euclid. So we can go on to the next slide here. Floating zones, and here's just a visual concept of what happens. We literally don't drop land onto the zoning map, but in principle, we are identifying a floating zone, and we'll show how that happens. So we'll go to the purpose of the floating zones, which is our next slide. So floating zones are often offer flexible development approaches that are not possible within Euclidean zoning. Except for Bethlehem and Eastford, every Connecticut municipality has wall-to-wall zones that pigeonhole every type of development into either a permitted or prohibited category. Floating zones are used to address a wide range of mixed-use development needs, higher density housing, transit supporting density strategies, or even special land uses that require long-range planning, such as assisted living for an aging population. And while a commission could enable these uses through a special permit process, as many municipalities have historically done, a floating zone enables the commission to tether controversial or less compatible uses to specific locations within a community best suited to handle traffic and other infrastructure requirements. When and where a floating zone lands within the authorized tether sites is determined by the marketplace, not by the wishes of the zoning commission. So we'll go to the next slide. So there's really a two-step process to create a floating zone. First, a text change is made to the zoning regulations that establishes the tethering standards, design and development rules. Second, an application is made to land the floating zone on a qualifying parcel using special permit or master plan review procedures. Once adopted, the zone is added to the town zoning map. There are public hearings for the first and second steps in the process. So we'll go to the next slide here. So what we have here is a picture of that floating zone, the mythical floating zone in this case, with hard tethers and soft tethers. Like any process that is developed over time, tethers have evolved to address hard and soft landing techniques for a floating zone. A hard landing is one associated with precise factors that link the floating zone to specific roadways, specific parcel sizes, specific road frontage requirements, access to public water and sewer, or even specific zones. And these are just examples. There's no single town that's doing all of these, but these are the types of things that are most prominently found in Connecticut. The advantage of the hard tether is that it provides the breadcrumbs that tells the developer and the public where the zone is likely to land. To the extent that tethers are created to address long-term development needs of the community, they operate in the public interest. In contrast, soft tethers are based on broad policy objectives such as protecting historic buildings, ensuring neighborhood compatibility, or protection of groundwater resources. These soft tethers rarely provide a clue to the possible landing sites for the floating zone. They're most useful after an applicant makes a request to land the floating zone, not beforehand. So we'll go on to the next slide. This gives you a summary of the floating zones that exist in Connecticut, and it really is dealing with the 20 most common ones because there's an enormous number of one-offs. Based on the complete inventory of all floating zones that exist in Connecticut as of last year, we find that mixed-use development, including planned development as well as age-restricted housing, are by far the most popular uses of floating zones in Connecticut. Yet it is important to understand that floating zones are also used for a range of housing, medical research, golf courses, and even agriculture preservation strategies. Floating zones can be used for strategic land planning for those municipalities that use their plan of conservation and development to forecast future development. For example, aging communities may wish to bake a floating zone concept for elderly housing or assisted living into their zoning regs and then promote its simplified approval process in the marketplace. It's a way of attracting development. The type of services needed in any given community change with time. To the extent that Planning and Zoning Commission can anticipate these future needs, the better it can serve its community and where a floating zone may be useful. And they are useful because they're flexible, easily implemented, and transparent in its tethering standards. This trifecta goal is not always achieved in practice, however. especially the need for transparency and public awareness of the purpose, scope, and potential landing locations. So we'll go to the next slide. So this shows you the types of hard tethers that we have. And of course, the top 6 right there, going from public water, there's 31 municipalities that use that. Specific highway tethers, 33. Zoning tethers, where you do it only within a certain zoning district or consistent with the plan of conservation and development, which may identify a location. And acreage tethers, which says basically you need 5 acres, 10 acres, or whatever the number may be. So this gives you a sense of the tools that are being used in Connecticut. And these are very important because these are the ones which actually tell you where it makes sense. At least the top 5 or 6 we just went over are some of the most useful that exist that we've seen in Connecticut. You can go to the next slide. Now let's go to the soft tethers that are adopted in Connecticut. By far the most common soft tethers are requiring the master plan to guide development and requiring the landing zone to meet compatibility standards, whatever that might mean in practice. Soft tethers are by definition more subjective approaches to ensuring the floating zone works where it lands. Since the zoning commission is unlikely to know where a floating zone will land, the soft tethers may sometimes operate as feel-good or subjective factors with little technical or scientific foundation and specific facts or studies about any given location. But when they're supported by evidence, they can carry more clout. So soft tethers tend to be points of negotiation with developers. Neighborhood compatibility represents the critical soft tether and is often addressed through stringent buffer and setback standards along the perimeter of the selected site, sometimes referred to as the landing site for the floating zone. So we'll go to the next slide to show some of the strengths and weaknesses. There are obviously advantages and disadvantages. Design flexibility is one of the key benefits. However, in the land of steady habits, which is our state of Connecticut, public expectations may perceive any change as a bad one. For this reason, one of the most important paths to success must rely on transparent and well-communicated notices to the community about the creation as well as the landing of floating zones. That's really just a process issue, but a very key process issue. So the solution to this challenge rests on the use of hard tethers that make the location or locations more transparent as to where the floating zone will likely land. That makes it much easier to convince the public, and that means your fellow residents of your community, that this is an appropriate location. We can go to the next slide. So here's some examples of the floating zones that do exist in Connecticut. And of course, as we said, they're from as small as a few acres to developments that may be hundreds of acres for a shopping mall. The tethering standards are strongly influenced by the type and intensity of anticipated development. For example, a regional shopping mall will generally require far more land development than a floating zone used to develop an elderly housing complex. A floating zone has even been created for potential village districts in Trumbull. Floating village district could land in multiple locations in that community based on what they're able to convince the community would make sense. So let's go to the next slide. Floating zones are litigation resistant. And as you see from the Supreme Court decision, the discretion of a legislative body, because of its constituted role as a formulator of public policy, is much broader than that of an administrative board, which serves a quasi-judicial function. This legislative discretion is wide and liberal, must not be disturbed by the courts unless the party aggrieved by that decision establishes that the commission acted arbitrarily or illegally. So the point is, floating zones are litigation resistant. They're not litigation proof. It's the difference between a Kevlar that stops a bullet and one that uh, actually maybe slows a bullet down. It's a difference of whether or not the community has actually followed many other particular issues, which we'll mention in the next slide. So the authority for floating zones was first established in 1969, which applied across all Connecticut, but many municipalities do not follow case law, Supreme Court case law. So in 2021, Public 2129 authorized the use of floating zones to memorialize that Supreme Court decision. But it's very important to understand that the Supreme Court is not giving a complete hands-off approach. The Riverbend versus Simsbury Zoning Commission decision says when a floating zone has only one place it can go, it is not a floating zone. It's a contract zone, and therefore that is illegal and held not to be a floating zone. So the key to a floating zone is that there must be at least two and preferably more locations where a floating zone can land. And at this point, I'll turn it over to my colleague, Tucker.
Thanks, Charlie. Next, we're going to review the use of planned development districts, how they're created and what they share in common with floating zones that we just talked about. So like floating zones, planned development districts provide much needed flexibility for a wide range of housing, commercial, and industrial applications. Unlike floating zones, planned development districts do not need to be created using these tether concepts, even though that's often one of the ways that they are applied. The key distinction, according to the Connecticut Supreme Court, is that these districts are established through a one-step activation process, whereas floating zones require that two-step process where they're created and then they're tethered. So as we've discussed, planned development districts can be created through various approaches. The three basic ways are through a special permit process, through simultaneous changes to the zoning text, the map, and administrative review procedures, or by phasing the approval process to approve the zoning text change, then making the final approval contingent on the special permit review process before finally mapping the zone. Planned development districts are primarily used to address multifamily and inclusionary housing needs currently. They're also used for economic development and transportation management purposes as well, as you can see from this map, from this chart. The uses of planned development districts are remarkably similar to uses found for floating zones. There's very little difference in the uses served by planned developments and floating zones. But the real differences are the procedures used to adopt the different zoning techniques. In many cases, it's hard to distinguish the two special development zone concepts until an analysis is made of how the two types are placed on the ground. The tether concept, as we said, being a key distinction in most cases. Next, we're going to move on to our third development type, which is overlay zones. This is the most popular special development technique across Connecticut, and we're going to talk about some of the ways that it's applied. Like floating zones, overlay zones provide flexibility in addressing unique environmental, design, and housing issues that don't necessarily align with the straight Euclidean zoning boundaries. For example, boundaries of things like floodplains, watersheds, aquifer protection areas, ridge lines, these don't coincide with the underlying zoning boundaries in a given town generally. Overlay zones are especially useful for these environmental protection purposes, but they can also be used to address housing, traffic, and neighborhood design issues. So there's two types of overlay zones in Connecticut. The first are those that are mandatory and establish supplemental regulations to those found in the underlying zone. The best examples of these are flood hazard overlay zones, watershed management zones, and aquifer protection area zones. The other case is where overlay zones create discretionary standards that don't change the underlying zoning unless a developer decides to adopt the discretionary standards through an application. The incentive housing overlay regulations established by the legislature in 2004 are an excellent example of this. These zones actually replace many of the underlying zoning requirements, but only once a developer chooses to apply for them. In this sense, incentive housing overlays operate much like a floating zone, except there's not a two-step legislative approval process. The zoning commission simply creates the housing incentive overlay in the legislative role, and then a developer applies to use the existing overlay zone for a specific property. In terms of different types of overlay zones adopted in Connecticut, um, more than 50% of all of the overlay zones, all 420 different overlay zones in Connecticut, are dedicated to environmental protections, addressing a wide range of concerns. Overlay zones are also commonly used for neighborhood design and inclusionary housing. More recently, overlay zones have been used to address traffic management and transit supporting density strategies. There are 421 distinct overlay zones in Connecticut within the 139 municipalities that use them. The 28 municipalities that choose not to use overlay zones are primarily located in the most rural parts of Connecticut with less planning capacity. So here are the most frequently used types of overlay zones. At the top, we have flood hazard zones, aquifer protection zones, and river protection zones. These are important to note because while they're not the river protection zones, while not specifically authorized by federal or state legislation, are enabled by Public Act 2129. It's the third most common overlay zoning technique in Connecticut, and it also helps to close the gap left by our state's weak riparian protections. Moving into strengths and weaknesses of floating zone or of overlays. They provide that needed flexibility to address a wide range of emerging environmental and development issues. Their main strength is the ability to deal with issues that transcend the boundaries of Euclidean zoning. Municipalities that use overlay zones tend to have the technical support of professional planners. One of the drawbacks of overlay zones, then, is that they create a more complex regulatory review process. Furthermore, overlay zones often overlap or are poorly depicted on zoning maps, resulting in public misconceptions concerning their compliance responsibilities. Overlay zones may also not follow parcel boundaries, and while allowing for flexibility, this can also lead to confusion as to the jurisdiction of the zoning commission concerning properties that are bisected by an overlay zone. So these niche cases need to be addressed in regulation. Moving on to geographic scope, like floating zones, overlay zones may operate at an intra-district or inter-district level, or even be limited to specific parcels within a community. Unlike floating zones, an overlay zone is almost always mapped once established, although not necessarily well mapped as we discussed. We will discuss the exceptions later in this training session. In terms of authority, the use of overlay zones to address flood hazard management was initially established in 1969. This was then expanded for coastal zone management purposes in 1979 through Public Act 79-535, and for broader usage since 1985. The Connecticut Supreme Court upheld the use of overlay zones in its 2021 decision concerning Tillman versus the Shelton Planning and Zoning Commission. And this brings us to our fourth type of district here, special development zone, which is the village district. These offer design opportunities for New England's villages without the restrictions imposed by historic district regulations. We're going to review their purpose and how they've been applied across Connecticut, because there's a wide range of ways that they've been used. The purpose of a village district is to protect and enhance the design and placement of buildings, to unify the appearance of a portion of a community that has special landscape, building, or design features. Despite their name, village districts are used to protect landscapes, building clusters, and also streetscapes that are unique to a community. Some center on traditional town greens, some are associated with fashionable retail centers, and some are connected to central business districts, while others are used to maintain the character of development along specific culturally and historically significant roads. Unlike historic districts, village district regulations are a part of municipal zoning regulations and must be created and modified just like any other zone change procedure. Since village districts may impact numerous existing buildings selected to become a village under Section 82J of the statutes, it's critical that the activation process start by involving affected property owners. It should be noted that on the bottom of the slide here, it says that a 2/3 vote is required if 20% of affected property owners or all property owners within 500 feet of affected properties file a protest. The recent House Bill 5002, which was just actually vetoed today, would have increased that threshold to 50% from 20%, which is something to note if and when we see that piece of legislation come back around in the next session. Unlike other special development zones in Connecticut, a village district created under Section 82J of the statutes must adopt 7 design objectives, the ones shown on this slide. As you can see, building layout and orientation are important for any new development to ensure consistency with existing neighborhood patterns of development. Micro-scale issues are also important, including lighting and signage, as these can affect the quality of the village district appearance. Unlike Euclidean zoning, where permits are granted to individuals to do as they see fit from a design perspective, under village district rules, individual design and placement decision are a team decision, relying on the expertise of the village district commission and the expert guidance provided by the advisory opinions of architects and planners. So what is district distinctive character? These objectives that we just discussed together form the framework of a distinctive character for a district, as defined in the Village District Statute, Section 82J. This requires zoning commissions to establish regulations to protect this specific character. This concept is associated with two other related concepts, the surrounding landscape and the historic structures within a designated village district. Yet the range of elements defining distinctive character must be interpreted within these 7 key statutory authorities of Section 82J. Public Act 2129 placed constraints on the use of the word character due to concerns the term was being used to exclude protected classes of people seeking affordable housing. The effect of this legislation is to qualify the use of the term distinctive character found under 82J to ensure consistency with the phrase physical site characteristics as seen in Section 82B of the zoning enabling statutes. Presented here is a model definition for the term physical site characteristics that can be used for any development. Except for the addition of the term site work, this definition carries statutory authority since it represents the language establishing the authority of zoning commissions to regulate land uses in Connecticut under Section 82A of the general statutes. The advantage of this definition is that it applies to all development coming before the commission. There are 71 municipalities that have adopted village district regulations, and virtually all have applied them to village town centers or other areas considered village districts, not only in name, but by tradition. Despite the typical applications of 82J, there are a wide range of other innovative applications, including enhancing scenic roadways, supporting economic development with a flair for design, and even to create a gateway zone at the entrance to a community. There's no legal limitation on how a village district can be applied, so long as it adheres to the 7 design and planning principles set forth in the statutes. For example, strip commercial development areas could be governed by a village district if the area in question had distinctive characteristics. Moving on to strengths and weaknesses. Village districts appeal to many Connecticut towns that still have intact village centers. Despite the design benefits they offer, though, not all municipalities have the resources to manage the regulatory requirements or to acquire architects and certified planners to assist in the review processes that are required. Overlay zones can also be used to implement village districts, which is an unusual synergistic approach utilized by the town of Trumbull. This allows for a more deliberative approach to convincing properties to join the village district at some point in the future. Like floating zones and overlay zones, village districts can be deployed at virtually any level, including as base zones, intra-district overlay zones, or for specific areas within one underlying zone. The authority for village districts starts from Public Act 98-116, which authorized village districts in 1998. This authority was modified in 2000 for greater flexibility in the design guidelines. Village district regulations have been upheld by the Connecticut Supreme Court as recently as 2016 in a case involving a village district in Newtown, Connecticut. More widespread use of village district regulations is limited by several factors, including the more detailed review procedures required to address architectural design issues, the limited availability of architects and AICP planners, and the level of community interest in protecting the character of Connecticut's charming, and in some cases vanishing, village squares and village centers. Village districts have precise design guidelines that apply to any district created under Section 82J. They're more than just a name. The statutory revisions made in 2000 to the village district statutes allows the Zoning Commission to use its plan of conservation and development to guide design decisions in the place of reliance on the Secretary of the Interior's rehabilitation standards. This is a significant improvement that simplifies the use of village district design options and tailors it to an individual municipality. You should also know that not all villages in Connecticut are protected by village district regulations. To achieve greater use of this statute will require increased public participation in the formulation of village district regulations. They don't work without local buy-in. As a zoning commission, you can play an important role in educating your community and fellow commission members on its benefits, both aesthetic as well as economic. And at this point, I'm going to turn it back over to Charlie to bring us home.
Okay, well, thanks, Tucker. So this is a summary of special development zones and a comparison of their features. While the special development zones are similar in many respects, there are also many differences. One major difference, as we've talked about, is that floating zones require a 2-step legislative approval process, and the planned development district generally require a 1-step approval process. In contrast, the other special development zones do not. Only floating zones require a tethering procedure. While floating zones and planned development districts do not require design considerations, many of the municipalities that use these 2 special development zones include detailed design standards within the scope of their legislative authority, often in the form of incentives for design or urban design features. In all cases, the plan of conservation and development is an important planning tool to implement special development zones across Connecticut. Behind all these special development techniques is a need to customize the regulations to meet neighborhood compatibility. That's an important consideration under all 4 special design districts. We've learned that village districts are uniquely authorized to address architectural, landscaping, and viewshed issues. We've also learned that floating zones have created standards that fall within their legislative authority to negotiate design-conscious development outside of traditional zoning and special permit procedures. So we'll go to the next slide. Some observations about special development zones. They are important tools to address development that do not easily fit into Euclidean zoning. Concerns with uniformity of zoning rules within a district have been replaced with concerns with inter-district compatibility, including appropriate buffers, setbacks, traffic issues, and infrastructure impacts. Overlay zones are an important tool to protect natural resources, and their widespread popularity is an indication that many zoning commissions now recognize their responsibility to address sustainable patterns of development. And we should say, for those who are not aware of it, the plan of development was eliminated in 1995 and replaced with the plan of conservation and development. So many of the environmental issues that we face today are really the children of that 1995 law that required the plan to be not just of development, but of conservation and development. And that is one of the reasons why we've seen such a growth in environmental related land use. You can go to the next slide. So one other set of observations. Finally, let's not forget the cross-fertilization occurring between these four development zones. An overlay zone can be deployed as a floating zone. A village district can be deployed as an overlay zone. And a planned development district can be deployed through a special permit process. These permutations of zoning techniques reflect the growing awareness that Euclidean zoning, while still an integral part of all zoning, does not have the flexibility to solve more complex, large-scale, mixed-use development proposals. And this is really why we felt today's presentation was needed, because so much of what zoning is today is not driven by the legislature or by case law. It's driven by zoning practice. And as a result, we have an enormous transformation of zoning from the days of the 1970s to what we have today. And I have tracked those during that period of time from the 70s onwards. And it is dramatic. And it is actually a step forward in the sophistication of zoning. We can go to the next slide. And this is just to give you some examples of short articles on the subjects that we've talked about today. There's a number that I think are very useful. Flexible zoning techniques by the American Planning Association, zoning, floating zones, a potential instrument of versatile zoning, by an article in the Catholic University Law Review are two very interesting ones. Even the Office of Legislative Research did a nice piece on village districts versus historic districts. These are all still relevant today, regardless of the date on those publications. And of course, for those who are interested in all of the training that we provide, there's a link at the bottom for the Land Use Commissioner trainings that we have given. And I think we've had at least 6 different ones independent of the one today. So I want to thank you on behalf of both of Tucker and myself for attending this 1-hour trade session, which is a basic orientation, not an advanced, the basic orientation to these principles of the special development districts in Connecticut. And you can access those 6 other land use training on our website by the link that you see on this slide. So at this point, Tucker, I guess we have a few minutes if we want to open it up to questions. Peter Lowe or Kevin Van Black, if you have any questions, we'd be delighted to hear your interests or concerns or questions.
No questions for me. This is Kevin, but thank you very much for the education today.
Okay. And Peter Lowe, anything at your end? No? Well, then in that case, did you say something?
No, just that this meeting, this presentation was recorded. The slideshow and this recording will be available on our website at the site at the URL listed at the bottom here. along with all of our past, right, all of our past trainings.
So, okay, in that case, I think we've concluded our session. We have a couple minutes left. So thanks again for attending. And if there's anybody in your commissions that is interested in this set of training sessions that we have, including this one, you can let them know about the this particular link at the bottom. And